Hello, everybody. Adam Bergman here, tax attorney and founder of IRA Financial. On today's YouTube Live emergency video, the CTA, the Corporate Transparency Act, shot down by an Alabama state court. What does that mean for you and your business? Do you still need to comply with the CTA, with the beneficial ownership interest report filing requirements for any new entity filed in 2024? Within 90 days of creating that entity and filing, you have a responsibility if you have 25% or more ownership, or you have substantial control over that entity, to comply and file certain information, i.e. your name, phone number, address, and piece of identification like passport, license, and let the government, FinCEN, Homeland Security, know who owns this entity. Now, the government has said that the only reason they're doing this is national security, right? And what happened and why this is super interesting is the National Small Business United, which is known as the United Small Business Association, NSBA, they sued Janet Yellen. And they basically are saying the CTA is unconstitutional. And they basically said Congress overstepped their powers and they don't have the right to do this based off a number of requirements like foreign affairs, commerce clause, taxation. Because of those elements weren't satisfied, the government doesn't have the ability to extract power over state rights. And state rights go to the creation of entities by the states, right? When you create an LLC or a corporation, you don't do it with the federal government. You do get a federal tax ID number, but you actually file to do business in that particular state by filing articles of organization or articles of formation. So this lawsuit basically has stated that the government overstepped their rights and responsibilities under the Constitution, and therefore the CTA, the Corporate Transparency Act, is unconstitutional. And March 1st, 2024, the U.S. District Court for the Northern District of Alabama, they ruled in summary judgment against the government. And they basically said that the CTA, which was part of the 2021 National Defense Authorization Act, is unconstitutional. Okay, so this is pretty big news. That's why I kind of went live on this. Now, listen, I'm not saying you should not file if you are forming a new entity within 90 days. There's still very stiff penalties, $500 a day. There's potential jail time up to $10,000 of fines. Again, this can go to appeal, which it will. This could actually go to the Supreme Court. There is no guarantee how any of this will play out. So I am still recommending to anyone who asked that, yes, go ahead and still file if you are within the 90-day period. Now, any entities that were formed prior to January 1, 2024 have until December 31, 2025 to file a BOI, a beneficial ownership interest report with FinCEN. Now, there are certain exceptions like tax exempts, trusts, IRAs, 401ks, companies that have more than 20 employees and $5 million in revenues are also exempted. But this Alabama state court ruling, I don't know if it's surprising because a lot of people felt that this was overstepping by the federal government, that they didn't necessarily have these rights and they couldn't show that the main purposes of this CTA actually satisfied national security. So I'm going to go through the ruling in some detail. I'll start with the lawsuit chronology, kind of go through what happened, and then talk about those major arguments that the plaintiffs and the government had and kind of show how the court ruled in favor of the plaintiffs against the government. So a member, I'm going to read a little bit because this is from the ruling. A member of the National Small Business Unit, the National Small Business Association, or NSBA, they filed suit on behalf of their organization against Janet Yellen, her capacity as Secretary of Treasury, and Himanali Das in his capacity as the acting director of FinCEN. They filed this on November 15, 2022. Remember, the CTA was brought to law in 2021. The NSBA alleged that the CTA's reporting requirements were unconstitutional and they exceeded Congress's legislative powers and infringed upon the members' individual rights on the First, Fourth, Fifth, Ninth, and 10th Amendments. Okay, in early 2023, both parties to the lawsuit, they agreed to proceed without additional fact-finding, no discovery, to get things done quicker, and they filed motions and briefs with the court to explain why the reporting requirements of the CTA should be held either constitutional or unconstitutional on part of the plaintiffs. There were oral arguments in 2023, and there was lots of briefing, lots of lawyers' work. And what did the plaintiffs want? So the plaintiffs wanted relief basically from the CTA. They basically said it's unconstitutional. We should not have to comply with the Corporate Transparency Act and make these tedious BOI filing requirements that come with lots of penalties, monetary, and also potentially 2 years in jail. Treasury and FinCEN, they filed, obviously, opposition briefs. Obviously, they felt that they had the constitutional authority and power to have the CTA, and it served their constitutional rights and powers under the Constitution. So what did the court do? Okay, so the court's decision rested on constitutional power. It didn't go into individual rights. It basically focused on the federal government's constitutional right to have the CTA go into effect. And the court's decision was largely based on the claim that the government had not supported its argument that the CTA was within Congress's broad power to regulate interstate commerce, oversee foreign affairs and national security, and impose taxes and related regulations. And Judge Burke was the judge that ruled in this summary judgment for the plaintiffs. So that's very important to understand. This was not individual rights. This was more on the constitutional power of the government. And this, again, was what the court was focused on. And the court, and I'll go through the ruling in somewhat detail, but in summary, this is basically what they said, is that the government did not support its claim that they had broad power to regulate. The CTA was part of their broad power to regulate interstate commerce, oversee foreign affairs and national security, and impose taxes and related regulations. So let's break that down. So the foreign affairs argument, the government basically argued that, hey, in relation to foreign affairs and national security, Congress has the right to pass the CTA because it's going to aid in national security, right? The main purpose of the CTA is not to catch tax cheats, right? This isn't an IRS thing. This is in the IRA checkbook control world. This is not about catching prohibited transactions. No. Congress and government's been super clear at its outset. This is about national security, and they've said it. We want to catch criminals, money launderers, and terrorists. And that's why we're doing this. We're not doing this to go after people for failure to file taxes or anything when it comes to tax or state matters. We're always focused on national security. And I give them credit for that. They said it at the outset. The government contended that the executive branch agreement with Congress creates a rational relationship between FinCEN's collection of beneficial ownership data and the advancement of national security interests. Okay. The judge didn't agree. And the judge said that the incorporation of companies is an activity within the incorporating state power that has and should continue to be independently overseen by the states. He argued that Congress enacted the CTA relying on their power to regulate foreign affairs, and they attempted to convert a traditional local activity to one of federal enforcement. So in summary, they basically said, we don't agree with you, government. Monitoring entities that were established under state law doesn't translate into your broad authority to regulate foreign affairs. So they shot him down on that argument, which is surprising because the government has very, very broad powers when it comes to foreign affairs. So that's why a lot of folks, and me included, think that this ruling may get shot down on appeal or by the Supreme Court, although the Supreme Court has tilted right over the years and definitely more state right leaning than before, right? More of the idea of state rights where the federal government should have more limited authority, kind of Judge Scalia mentality, less federal intrusion into state rights. So this could play well into that argument, although it may get shot down on appeals, but I do think ultimately it could go to the Supreme Court. Okay, the Commerce Clause, which is the next area that the court looked at. So the government basically said, okay, they had the power to enact the CTA because Congress has the power to regulate channels and instrumentalities of interstate commerce, in addition to activities that are substantially affect interstate commerce, right? This is the clause the government always uses. It's like their get out of jail free card, their wild card. They always use interstate commerce. If you read a lot of constitutional cases, it's always, when it comes to federal rights and federal authority over states, it's always interstate commerce clause, interstate commerce. That's what they've always used. But here, the court disagreed. And they said, what Congress is regulating, a channel or instrumentality, which is exemplified broadly as a road or car, respectively, he said the more lenient substantial effect justification also does not satisfy the court because the CTA is neither a piece of broader regulation nor attempting to regulate commercial activity by the plain meaning of the words of the statute. And the court pointed out that the word commerce is not even in the CTA legislation at all. The word commerce is nowhere to be found in it. So they felt that, yes, Congress obviously does have the right to enforce the Commerce Clause and interstate commerce, but the CTA is not really about commerce at all, right? It's just probably more of a national security. That's why once they lost the foreign affairs national security argument, you kind of saw the writing on the wall that they were going to also lose the Commerce Clause, because in this case, the CTA is really less about managing interstate commerce, because the CTA is all it is just disclosure information about state entities. It has nothing to do with interstate commerce. So I kind of agreed with Burke on this. I thought Burke was very aggressive on his foreign affairs arguments. I'm surprised he went there. Usually a lot of judges, but again, this is a Southern judge in Alabama that is probably more focused, probably a Republican, and certainly more focused on state rights. So interesting. That's why I always loved constitutional law. When I went to law school, it was always one of my favorite topics. It's hard, other than being a law professor, can't really do anything with a constitutional law focused law degree, but it's always super interesting. So anyways, they lost the foreign affairs and they lost the Commerce Clause argument. So then it was the taxing power, right? We know that Congress has a right to tax. And the plaintiffs, meaning the business association, they conceded that if the civil fines, right, that $500 a day, if that was deemed a tax, then they conceded that Congress would have the authority. But the judge agreed that fines are not taxes. Okay, so the civil penalties are not taxes. So they lost that as well. And then ultimately the court said the penalties for noncompliance are so egregious that they have to temporarily suspend its legality because in the case of the National Small Business United, if they're in flux and they're not sure what to do, the $500 a day penalties and the $10,000 is so egregious and the potential jail time that the court had to step in and basically pause this because they wouldn't know what to do. Should they pay it? Should they not? This could go to appeal, it can go to the Supreme Court. So basically what this ruling does is this ruling really only, in the sense it has broader importance, broader significance for all of us and greater potential impact. But from a ruling standpoint, it's really only impacting this National Small Business Association, this NSBA, and basically just say that they don't have to comply right now until there's further guidance and further action in this case. Personally, I strongly advise people continue complying with CTA, even if you don't believe it has any legal justification and the federal government overstepped their boundaries and jurisdiction. Let the courts determine that. In the interim, I would comply. Again, I'm just going to say I've had clients reach out about this because, again, if you have a checkbook control IRA LLC or if you use a 401k with an LLC or corp, because even though the IRA and 401k is exempt as the owner, but whoever has substantial control over that entity, you have to disclose that individual's information. So we're doing that for our clients. And I keep telling people, listen, they're not going after IRS privileged transactions or UBIT. This is not anything to that extent. This is really focused on, it is national security. I truly believe that. That's why I'm shocked on this ruling, because the government does have broad powers, and there is a fair argument to say that, hey, the more information you have about these entities, maybe you have an easier time to crack down on foreign terrorists or bad actors that are operating with not the best interests at heart that could obviously prove very troubling to America and our interests. So I get it. It's just a very surprising ruling. That's why I wanted to go live on it. I would, again, recommend strongly keep complying with the CTA. Even if you don't agree with it, keep complying. Let's see what the appeals court does. The 11th Circuit Court of Appeals will probably hear this case. They could overrule it. And ultimately, I think the Supreme Court may hear it if that's the case. And then it'll be interesting because you're going to have, the state right justice against some of the, some of the other justices that may feel that the federal government does have a national right to do this based off. I think it's more of their foreign affairs rights. I think the Commerce Clause is a hard one to win. The taxing authority, I think it's basically, hey, Congress has the ability to oversee and protect the national interests of the country. And listen, I think there is some credibility to that argument that the CTA does help them do that. Now, I don't personally think so, because if they did, then why limit the CTA to just entities with under 20 employees and 5 million in revenue? Like if I'm a bad actor terrorist, I can invest in companies that do more in revenue, right? And somehow siphon those profits off to do bad deeds. So there's ways to get around this. You can keep the ownership low. You can own multiple entities. They're doing other things too. So I think it has the effect that it could help the government potentially go after bad actors, but there are so many workarounds and there's so many exemptions to the CTA that I think if you're a smart bad person that wants to do bad stuff, you'll find workarounds, or you'll get some other person to comply, or just lie, or just not file it, or use trusts. Right? There's so many ways to get around this thing. Like I just thought about it for a few hours. Like if I was a bad actor and I had days and days to think about getting around this, you don't have to be that smart to figure it out. You can use trusts, right? If it's just a trust, you don't have to file a CTA. Or you can just invest in larger companies to launder more money and to do more bad things. So anyways, this is very, very surprising ruling. Again, for the record, I would strongly recommend everyone to continue complying with CTA. Even if you are heartened by this summary judgment ruling by Judge Burke in the Alabama District Court, Northern District of Alabama. It will go to appeals, 11th Circuit, could go to the Supreme Court. I don't know where it's going to go, obviously. I think there's good arguments on both sides, but I am surprised, just for the record, that they lost in summary judgment, because I'm surprised that the judge didn't think that federal government didn't have some justification for the CTA based off foreign affairs and national security interests. So who am I, right? I'm just a tax lawyer. That's why I didn't become a constitutional law professor. Maybe I would have had a wiser thought, but I didn't think this case was going to do anything. There's some other cases floating around the country, similar arguments. There's also going to be some arguments for individual rights. I mean, this is an important part, that this decision did not address individual rights provided by the Bill of Rights. Okay, this was case focused on constitutional power, not individual Bill of Rights. There will be other cases potentially on the individual Bill of Rights. Why? 35 million or so companies could be impacted by this. Lots of Americans will be burdened. It's not hard. We do it for our clients. It takes 5 minutes. But again, it's scary. People may not know about it. You have all year to do it for entities that were filed before January 1, 2024. People forget. They're not. It's not like it's all over the news and this is all people are thinking about, right? There's other stuff going on. So if you forget, penalties are steep, potential jail time, and it's somewhat burdensome. So I guess the court ruled the burdens with the potential rewards to the federal government from a national security standpoint. And I think from a constitutional perspective, they agreed with the plaintiffs here and ruled that the federal government overstepped their constitutional power. So to be continued. That's kind of all I wanted to talk about today. I hope you guys enjoyed today's live. That's why you should subscribe, because I just go live when I want to. If something pops, something's interesting, current events, newsworthy, whether it's about IRAs, 401ks, for alternative assets, taxation, who knows? I'm going to go live. So if you subscribe, you'll get notified. You'll be able to catch the video anytime you want. So it's free, right? Might as well subscribe. Generally do 3 to 4 videos a week, drop 3 podcasts a week. So if you're looking for really good, updated content, and I put a lot of effort in it, I don't think you're going to find many people in the country that know more about self-directed retirement accounts, taxation than me. Not that I'm so great, but I do have a law degree. I have a master's in taxation. There's a lot of lawyers out there that are commenting on self-directed retirement accounts, but ask them if they have a master's in taxation. Ask them if they were a tax attorney, for 8+ years at some of the largest law firms in the country. So when you put it all together, yeah, I think I know this stuff better than anyone, and I'm happy to debate anyone on the stuff. So I hope you guys enjoy the content. I do it for you guys. I do also love it, and I like learning. I get some great feedback and questions. Just got a voicemail today from someone on a YouTube live idea and topic. So keep them coming. You can send comments, questions, call us, chat us. If you have questions, you don't even have to be a client. We'll try to get you the right answer. That's how much we care. But I just love this stuff. It's so much fun. And ultimately, the goal is the retirement system is rigged in our favor, and it's not a zero-sum game. We all can be rich. It's based off the power of 72. Get an 8% rate of return, 9 years. You'll double your money. You double it quicker if you get a higher rate of return. It works. It just takes time, patience, trust the process, be consistent, good habits, and you will have tax-free wealth when you're older, I promise. And it's not just for you. It's a tax-free legacy for your family, your spouse, your kids, grandkids. So it's the best way to save. Don't trust me. You can trust Albert Einstein. He said count planet returns is the 8th wonder of the world. But in this context, the CTA is on life support. It's not dead, but it's on life support to be continued. What the 11th Circuit does, and potentially ultimately what the Supreme Court does. So thanks for watching. Hope you guys enjoyed the video. Have a great day. Thanks a lot.